Case number 115067, Michael McCullough and Kenneth Risley v. Devin Lee Wilson.
Court, please. My name is Frank Hummer. I represent the defendant, Mr. Wilson, in this case. I'd like 2 minutes, Your Honor.
2 minutes is reserved for rebuttal.
Thank you. And for the benefit of the audience, some background. This case is a civil case, not a criminal case. Thank goodness it doesn't deal with DUI. It deals with an issue involving the interaction of insurance companies and their personal injury protection benefits for medical expenses. The facts are that Mr. McCullough and Mr. Risley were occupying a vehicle by themselves when it was rear-ended by my client, Mr. Wilson. Both Mr. McCullough and Mr. Risley applied for their own personal injury protection benefits through their own insurance companies. Both were paid, and nothing happened until one day before the statute of limitations ran. That's when the lawsuit was filed. One day before the statute ran, more than 18 months as contemplated in the statute we're talking about. But I was incorrect. What did happen is that Mr. McCullough's PIP carrier, before the lawsuit was filed, after 18 months, asked my client's own liability carrier to reimburse its PIP benefits, and that happened. AAA, the insurance carrier for Mr. Risley, did not do that. It did nothing. After the 18 months, when the cause of action was assigned to it for those PIP benefits, it just sat on those rights. 2 years ran, statute of limitation barred its claim. In this civil litigation, just shortly before trial, I filed a motion and asking for judgment on those medical expenses, and that's when these issues arose. The trial court took my motion under advisement. We went through the trial. Post-trial, the Judge Alvey renewed her attention to that motion, ruled in favor of my motion on Mr. McCullough because it was admitted, frankly, by the plaintiff that yes, his PIP had been reimbursed. She ruled against me on Risley, finding, we had oral arguments, she made an oral ruling. I asked her for clarification. She said she believed that the legislature did not intend for a tortfeasor, my client, to benefit from that assignment contained in 403113A, C. She felt that since the PIP carrier didn't assert its rights, it was a windfall, whatever that means. And she felt that my client should not get the benefit of that windfall. We appealed, the Court of Appeals, in a fairly lengthy opinion towards the tail end, pretty much adopted that windfall position. But more importantly, the Court of Appeals delved into a couple of cases in more detail. I'm looking at this as a plain language case. I say the plain language of the statute is unambiguous and does not lead to an absurd result. Neither the trial court nor the Court of Appeals found the statute to be ambiguous, neither found it to lead to an absurd result. They just didn't like the result because a tortfeasor got the benefit of the statute. So they legislated their own policy into their decisions, at least at the trial court level, at the Court of Appeals level. I believe that panel relied on some cases that were wrongfully decided. I'm asking you to take another look at them and reverse them.
Do we have to do that to get to where you want us to be? Do we have to overrule prior cases?
Because the Court of Appeals relied so much on the Fayview case, I think you almost have to. It was, I believe it was the exact same language. You could find it was dicta in the Fayview case that it dealt simply, it didn't have anything to do with the real issue, that being a procedural issue, how much two lawyers were gonna have to do in the trial of the case. It's my belief that the language used by the Court of Appeals in that case, dealing with our statute, was totally unnecessary to the real issue, and that's the procedural issue and the exercise of the trial court's discretion on how much two different lawyers were gonna get to participate on behalf of the plaintiff.
And when you say the plain language, you're relying on that part of subsection C that speaks to the failure of the tort or the insurer or the insured to file suit, then the insurer that failure shall operate as an assignment.
Correct. Yeah.
Okay, that's an assignment from the insured to his or her insurer.
To his or her PIP insurer, yes.
Correct. So, where do you come in? What's the tortfeasor got to do with anything? I mean, this assignment is as between the insured and his PIP insurer. And even if it operates as an assignment, I guess what I'm asking you is, why does the tortfeasor get to enforce an assignment, a right that the insurer got from its insured?
An assignment transfers all right, title, and interest from the assignor to the assignee, and
So
according to our case law.
did you raise this as a real party in interest?
I did.
But I didn't get that you're arguing that on appeal or
I
on
believe I
review.
am.
Okay, all right.
If I may finish, our case law says that an assignment transfers all of the assignor's right, title, and interest to the assignee and completely divests the assignor of any control over the subject matter.
That I'm aware that you've cited as that, but we also have case law that says that the assignment is complete when it is assented to by both the assignor and assignee. And where here did AAA assent to taking an assignment? An assignee doesn't have to take assignment.
Our case law describes that as self-executing. Our case law does not say the assignment in this section needs to be assented to by the PIP carrier. The statute doesn't say that. The statute is without any limitation, any condition whatsoever.
Well, let's look at the statute. Let's look at the next sentence. Such insurer or self-insurer may enforce same, I'm assuming the same means the assignment, in such person's own name or in the name of the injured person, etc. So if the enforcement can be done in the name of the insured, how can that be? How can the insured be totally divested when your cause of action is brought in that person's name?
Happens all the time. Every liability insurance policy, particularly property damage, you'll find that the property insurer is granted a subrogation right that can be brought in the name of the insured, that subrogation right, or just in the name of the insurer. The 44504, that statute in Lady, says the same thing.
You're talking all the time argument, but you're making your argument on the plain language.
I am.
And the plain language doesn't give the tortfeasor the right to enforce the assignment.
If this was an assignment and Mr. Risley was divested of all right, title, and interest and divested of all control over his cause of action in tort for the PIP damages, he had no standing to bring it in the first place.
But it can be brought in his name.
And AAA did not do that. This was his loss.
That's my disconnect.
Sure.
If he has no right, title, or interest and no standing to sue, then how can the suit be brought in his name?
because the statute says so, because liability insurance contracts mirror this kind of language where the insurance company can bring that subrogation right in the name of the insured if they choose.
Is there a parallel to be drawn? I've been trying to make it with commercial real estate transactions where the mortgagee would be secured by an assignment of rents in the event of default, and our law is that the mortgagee can affect that assignment of rents, but the mortgagee has to take steps first. In other words, it doesn't automatically happen at default, and you're saying it automatically happens at 18 months.
Correct.
But our law on the commercial real estate side of the world talks about the mortgagee's assignment of rents doesn't become effective until they take a legal action. And I'm wondering if that isn't the same thing here, because the insurance company did not yours, but the insurance company did not take action after 18 months, and so no assignment went into effect. You see what I'm asking?
Sure. I don't do real estate work, Judge. All I know is the statute doesn't say that. We have case law that has described this as a self-executing provision, not needing anything else like they do in the real estate side. And gotta keep in mind, the legislature did something that frankly I've never seen done before by taking away a cause of action from a litigant, taking it away and assigning it to somebody else. Completely contrary to our prior statutory and case law that says you cannot assign torts. They went to, in my view, pretty far degree when they said this is an assignment of a tort cause of action.
And see, my concern is if I define the word assignment the way you want us to, that I'm going to affect a lot of law on the commercial real estate side of the world when it comes to assignment of rents, because those don't trigger, as I read the case law, and as I remember back in the day, those didn't trigger until the mortgagee took a step. And again, your insurance, and the insurance company in this case didn't take a step. So I'm just not sure whether the statute took away the right to pursue those benefits from the plaintiff as opposed to made it vulnerable to being taken away.
Sure. The only thing I can suggest to you there is that our No Fault Act is pretty broad and encompassing. In 74, we totally changed all of the law in motor vehicle accident litigation with PIP, with providing barriers to a lawsuit for personal injuries. Got to have a $2,000 threshold, broken bone, so on and so on. Changed it completely. And I hate this phrase, but it's pretty much complete unto itself. And in 74, the predecessor to this statute, 403113, was a mess. It was a horrible mess that required prior notice to the insured before the company could take steps to reimburse, putting names on checks, putting and if you didn't put the company's name on the check and you paid by mistake, then you could have to pay a second time. It was a mess. And so when they went through and changed it, they changed entirely this subsection. They completely revoked the old subsection C, wrote this brand new one with clearly spelled out rights of an assignment, unqualified. Nothing about you have to go out and do something in advance to get the benefits of that assignment. The legislature wanted that. And again, if you're right that that's long-standing in our real estate field, we have to assume the legislature knew that, but they didn't write that into the statute in 77. There are no limitations, no qualifications, and particularly there's no provision that under any circumstances is the assignment reversed as Judge Alvey at the trial court level and the Court of Appeals want to see it done. The Court of Appeals, not only in our case, but in Favo and prior cases, said this is really not a true assignment. And maybe they were trying to get at what you were just mentioning, Judge. I'm not sure. I looked throughout our cases, I couldn't find a phrase, quote, true assignment anywhere in our case law. And the corollary, I couldn't find any case law that talked about a, quote, false assignment, close quote, anywhere in our case law. I don't know what that means. Under our case law existing at the time that statute was enacted, it passed every right, title, and interest to the assignee, and it divested the assignor of all control over that particular item. And I think that's what we have to read into this without any limitation, as the Court of Appeals suggested, as...
Well, before we start reading into, I've got some more plain language here I want to ask you.
Sure.
Because the operate as an assignment, that's what you're focusing on, but get to the end of that. And it says, for the purpose and to the extent of recovery of damages which are duplicative of personal injury protection benefits. And so it's not for all purposes, because if those medical bills, if there were payments made by the insurer that were not duplicative, then that's not subject to the assignment.
I agree.
And so I don't understand how you can say it's self-executing when there has to be a factual determination of what's duplicative.
One's got nothing to do with the other. It's the best way I can answer you.
Well, let's back up. It says, it doesn't say assignment. It says assignment for the purpose and to the extent of recovery of damages. And so that's assigning them for the purpose of recovering the damages from the tortfeasor.
But only to the extent of the duplication of the PIP, nothing more. And that same language, Judge, it doesn't change the statute of limitations at all for the plaintiff. They still have 2 years to file a lawsuit. The only thing they're losing is, if it's applicable, is the damages equal to the duplicative PIP. The cause of action for those damages has been assigned to the PIP carrier. So the Court of Appeals and plaintiff here, and they were worrying about statute of limitations. How can you shorten up statute of limitations for a plaintiff? The same argument in the lady case, the work comp case, where the poor widow and orphan were trying to get a few bucks, and they said, well, you can't shorten up statute of limitations. I'm not suggesting that one bit. All I'm suggesting is that some limited amount of damages has been taken away from the plaintiff by the legislature and assigned as a cause of action in tort to the PIP carrier. That divests the plaintiff of any right to recover that. That's the real party and interest issue. The plaintiff, when the lawsuit was filed, had no right to recover that PIP because of the self-executing assignment language. I'm out of time.
And the windfall that the lower courts were concerned about is because no action was taken against your client.
Because the PIP carrier chose to do nothing, that left the plaintiff still without a cause of action in tort for the medical. So my client should not have to pay that medical for Risley, just like we didn't have to pay it for McCullough, different reasons, and that is that the plaintiff still didn't have the cause of action in tort for the PIP. There was nothing in the statute that says, oh, by the way, if the PIP carrier does nothing, you get it back. That's not in here. There's no condition, no limitation, no reversionary language. So if he didn't have the cause of action after 18 months, still didn't have it at the time of trial, can't recover the PIP medical.
But it's not like McCullough because the tortfeasor paid those medical bills.
But at the time
They
of...
paid him to his insurer, but they paid, the tortfeasor accepted and paid its liability for the tort.
That's exactly right.
But you're asking that the tortfeasor not be required to pay its liability because AAA didn't seek subrogation.
Correct. But it goes one step further, Judge, and that's because the plaintiff Risley, after 18 months, was not the real party in interest to pursue a claim for those duplicative PIP medical expenses. And he never got it back, simply because AAA chose to do nothing. Doesn't mean that the assignment was reversed. He just never got it back. And so at the time of the trial, I said, go ahead and let the jury see the dollar amount of the meds, kind of like an auto case where liability is admitted, but you let them see the photos and speeds to try to figure out, how bad was this wreck really. I suggested put the medical up there, let the jury put it on the verdict form, but still reserving my argument. And after trial, Judge Albee said, yeah, you're right, you don't have to pay McCullough's. You're wrong, you don't get the windfall, you have to pay Risley's. That's how we got here.
Any further questions? Thank you, counsel.
Thanks, Judge.
May it please the court, good morning. My name is Stephen Nichols, appearing pro hoc vice for the appellee Kenneth Risley, who to this point in time has been successful in maintaining the integrity and purpose of the Kansas Auto Injury Reparations Act, I should say. And that kind of follows the theme of my argument. If it's not broke, don't fix it. There's simply nothing broken here. For 40 years, Kansas injured in automobile collisions have been able to obtain compensation for their damages, medical expenses, and other things through the no-fault and tort system, which has been well understood and streamlined. There's been no multiplicity of suits. There's been no double recoveries that I've ever seen in 38 years. And that was the purpose of...
How can you say that? Hasn't your client received PIP benefits?
My client received PIP benefits, which he was entitled to under the Act. And not because of KRA did he receive any double recovery. He received the benefit of the jury verdict for his medical expenses only because his PIP carrier made the decision, as does happen from time to time, that they didn't want to insist on subrogation.
That's still a double recovery.
Well, it is if you consider that he paid no premium for that insurance. I doubt that there's ever a double recovery, a true double recovery. I hear that all the time, but folks pay a premium for personal injury protection benefits. And so, I have a hard time as a plaintiff's lawyer with that double recovery stuff because it just never really pans out, quite that way. And again, as Judge Johnson was saying, this is not really the tortfeasor's argument to make here. KRA doesn't say anything about protecting the tortfeasor. It's between the no-fault carrier and the injured party, the purpose being to obtain prompt compensation for the injured party without having to go through a tort case, and protecting the PIP carrier against double recovery. If it wants to be protected, it has the right to decide that, hey, we don't want to subrogate, you go right ahead, because the tortfeasor is always liable for the medical expenses. It can't complain that either the PIP carrier or...
That's not exactly true. They're always liable for the excess. That's the whole point of no fault, is the first, that you couldn't sue for the first 2,000 or whatever.
Yes, that is...
So they're always liable for the excess, but that was the purpose of no fault, to do away with the as many lawsuits.
That is correct. That's right, that 2,000 limit or a bodily injury, major bodily injury, system injury, that's correct.
So
but
basically, they're tortfeasors or a third-party beneficiary of the no-fault law that precludes suit.
To that, yes, to that
And so
minimal
why would
extent.
they also be a beneficiary of the
Well,
subrogation statutes?
Well, I think because they're not paying anything, it's the no-fault carrier that has the initial obligation up to $4,500 to pay. And so the legislature's intent is to protect them in getting that money back. And the injured party always has that obligation. And that's something that I wanted to point out. Even if there were this assignment, under the case law, the plaintiff can always settle the case or something of that nature and bind the PIP carrier to what they did, despite any of this assignment language. That's why I don't believe, as the Court of Appeals did not, and as this court did not in Potts versus Goss back in 1983, did not believe that there was any kind of true assignment in the sense of a total divestiture.
Let me understand your argument. The injured person in that period between 18 and 24 months has the right to settle with the tortfeasor. That includes a determination of the amount of the medical and even duplicative PIP. Do we have case law that says that can be done, which would refute the fact that the injured person doesn't have any remaining rights about being assigned away?
What I'm saying is that, like, say at month 20, the plaintiff wants to settle with the tortfeasor. They're free to do that. There doesn't really have to be, allocations of how much. That injured party is going to be liable to the PIP carrier.
Does the PIP carrier have to consent to that settlement,
No, they do not.
even though their subrogation rights are involved?
Right, they're protected by subsection B of 3113A. That gives them a complete right to subrogation, that they don't need to do anything. And that's why I disagreed with Mr. Hummer when he kept telling the district court that somehow in this case my client would have, after the 18 months, suddenly had no subrogation obligation to AAA. I couldn't imagine that being the case in light of the statute. I wouldn't for 1 second try to, get away with not, recompensing AAA had they not decided that they didn't want to. And I had seen nothing in the case law that would ever suggest that after 18 months, an injured party has no further subrogation right against the PIP carrier, which is what was argued to the district court. And plus, like the Court of Appeal said, and I think this is very important, if this kind of interpretation were given, it could result in a multiplicity of suits, because theoretically, every time somebody sued at 19 months, the PIP carrier would have to file a suit in its own name to protect its subrogation interest. Because according to the appellant here, the injured party would have no further right to collect that part of the medical expenses, which seems to run contrary to what we're trying to accomplish with the no-fault law, which is to avoid the need for that. And then, so what if the plaintiff then would sue at month 21 after the PIP carrier sued at month 19? Now we've obviously, you would probably should have a consolidation issue. But just look at the potential procedural quagmires that are so unnecessary under this law.
Well, counsel, on the subject of what was intended, what this law is intended to do, under your theory of the case, what do you think the language means when Section C says, shall operate as an assignment? What does that mean?
I think it was to clarify from the 74 statute that traditional concepts of subrogation, which this court discussed in Farmers Insurance versus Farm Bureau in, I think, 1979, explained very well in that case, typically involved you having to bring suit in the name of the injured party, at least at common law and sometimes even contractually. And so I think the legislature was trying to say, and it's hard to know why that language was necessary, except to get rid of the 30-day notice, which was important to streamline it, I think. But I think that was a signal to PIP carriers that, hey, you could sue in your own name. You didn't have to name, the injured party in that case. And we see some of the problems with that in the O'Donnell versus Farmers case that was a Court of Appeals case in the dissenting opinion particularly, where the judge was hung up on the fact that the PIP carrier was trying to sue in the insured's name, but only claiming damages for itself, for its PIP benefits, instead of all of the damages that the plaintiff would be entitled to, which is what the PIP carrier would have to do under traditional notions.
That whole explanation makes sense, but I guess the problem I have with it is that we have to go really far afield from the language of the statute itself to get there. don't we?
Well, I don't think so. I mean, courts have had 41 years to do that.
Well, the only
and-
way to get, maybe not the only way, the way that I think, that I perceive courts in the past have gotten past this language that I'm focusing on is by just saying, well, that's not a quote-unquote true assignment. Is that the only, is there another way to get around that language or to get over that language from your perspective, other than just saying, well, it doesn't mean what it says it means?
Well, and part of it may have to do with Judge Johnson, what he was saying about the assent. You know, it says they may. I don't know that the PIP carrier, I think the PIP carrier has some choices here on whether to accept any assignment or take on that right.
Well, it's not, it doesn't stop after assignment. It says for the
Right.
purpose and to the extent of recovery of damages. What does that mean? Is that a limited assignment?
Yes.
And, but the problem is if we do find that, well, that's a limited just for enforcing your subrogation rights. But how does that retain for the injured person the right to also go after those individually, rather than on behalf of the insurer? Because the insurer's already says, hey, I don't want the money.
Mm-hmm.
You follow what I'm saying? So you got two steps here. You can say, okay, that's limited. That the purpose of the purpose of recovery of damages shows that the assignments so that the insurer can take care of the subrogation rights. But the next step is how does the injured person retain the right to go after duplicative damages in its own name, not on behalf of its insurer? You understand what I'm saying?
Right.
When you're settling, in your example,
Right.
you're settling, but the insurer's obviously doing it on behalf of for the PIP damages on behalf of its insurer, because there's a subrogation right in B.
Right. Right. He's theoretically wants to settle for all of his damages, which would include those duplicative PIP benefits. That's right. But my view would be that nowhere has the legislature or the court said that, you know, suddenly an injured party loses its right to go after all of its injuries within the 2-year statute of limitations. And that same 2-year statute applies both to the PIP carrier, of course, and to the injured party.
But
So
is the legislature saying that they no longer consider that party to be injured to the extent of the PIP that they've already received? Their damages are no longer over here, they've been moved back to this point?
I don't know that they're saying that the party's no longer been injured. I think the real crux of this, and going back all the way to the 60s when you look at this, is to just protect, given that we're giving a public benefit and that there's no fault, this company has to pay, we want to protect their right to protect themselves if the injured party fails to do so. And that's the only time when we've seen in a lot of these cases that an insurance company has actually, a PIP carrier has actually directly sued the other insurance carrier, is when there's been a failure of the injured party to take any action, which is what the intent of the statute was. But there's no reason why a PIP carrier wouldn't rely on the injured party to be able to bring, you know, the full case, because they're protected with you know, as long as that injured party sues within the 2 years.
Well, you wouldn't.
They're protected.
You wouldn't make that argument if there had been let's say this statute doesn't exist,
Okay.
and there was just a contractual assignment that was valid, and we're not arguing about it. It's a real assignment, contractually valid.
Okay.
Like, you wouldn't be making the argument that the insurance carrier in that circumstance would then still be able to rely on the plaintiff to bring the case when they received the assignment. I mean, don't we circle back to whether or not there was an assignment?
No, I think that if there was a contractual assignment,
Then in that case, the party receiving the assigned interest would be responsible for vindicating that interest, would they not?
well, they couldn't Well, technically, they couldn't receive that of a tort claim.
I understand that
Oh,
there are
I see
other
what you're saying.
but just hypothetically speaking, if
Yeah.
we're talking about the responsibility of the parties.
But the next step is who are the parties? The assignor or assignee, does the tortfeasor have the right to enforce the rights of the assignee if the assignee declines to enforce them? Isn't that what we're really talking about
Yes.
here? No one, I don't think there's anyone, if there was a fight, like in the Fauview case, they were fighting over who gets to control the lawsuit, but that was between the assignor and assignee. Here, there's no fight between the assignor and the assignee, who are the two parties to that contract.
Right.
And the only way you get to the tortfeasor has a dog in the fight is if somehow it's a third-party beneficiary of the assignment. Or you get to the point that it's as a matter of law, it divests the injured party of any rights with regard to that and cuts off their statute of limitations by 6 months.
Right, and that's never been held to this point in time, either in the workers' comp situation, which is very similar, or in this context. And that's why I think, I mean, that would involve perhaps overruling a lot of cases, as somebody here was mentioning earlier. So, well, thank you very much. I'm out of time.
Do you have any further questions? Thank you, counsel.
I still have 2 minutes, Your Honor.
You have 2 minutes.
We are not suggesting that the tortfeasor is asserting any rights the PIP carrier has. We're saying that the assignment completely divested the plaintiff of any cause of action in tort for the PIP medical. He had no standing to raise the claim in the first place. He was not the real party in interest with regard to that claim and could not make it. I'm not saying that the tortfeasor is the same thing as the PIP carrier, not one bit. But even if I did,
Now, if those payments from AAA to Mr. Risley were not duplicative, then how does that affect your argument?
the assignment doesn't apply. They have to be duplicative of what's asserted in the lawsuit.
And what if AAA is saying we're not seeking subrogation because we don't consider them to be duplicative?
Well, that's a fact question. Somebody's going to have to decide at some point in time.
You mean the
But
insurer can't agree with its insured that the payments it made is not duplicative? They have to go to trial to determine that? Why can't the assignee says, I'm not going to seek subrogation because I didn't pay you any duplicative medical bills?
Well, here, that was done by AAA in a letter long after the statute of limitations barred its own claims. It had no valid enforceable claims of subrogation at the time it drafted that letter, if you're talking about this specific case. If you're talking about in general, hypothetically.
I'm back to you're saying you're not asserting any rights of the assignor, but you have to be because you're asserting the right that these were duplicative payments. Otherwise, this assignment doesn't apply. That's a factual determination that you have to, that's normally the fight would be between assignor and assignee. So you have to jump into that fight because it's not an absolute assignment of all medical bills. It's for non-duplicative personal injury protection benefits.
I agree that's what the statute says. There was no fight here in this case over what that dollar amount was because it was not acknowledged it was duplicative.
Is that a fact finding? Is that in the record as a finding or stipulation of fact?
It could very well be reflected in the transcript of the oral arguments post-trial. The dollar amounts paid. In fact, Judge, I think it might have been in the motion that I filed that started all this, or maybe the supplemental motion. Because it was the dollar amounts that the PIP carrier paid were the exact same dollar amounts both plaintiffs were seeking in the lawsuit. But there's been no dispute in this case.
Yeah, that's your position, is that that is an uncontested fact.
Yes,
The duplicative nature of the benefit.
yes.
Yes,
There's no dispute here on that. But
Judge Alvey's finding that it would be a windfall get you there? I mean, does that infer that it would be a duplicative payment, or otherwise it would not be a windfall?
most likely, because that meant my client didn't have to pay any of it, because the cause of action was assigned to the PIP carrier and took away that cause of action from the plaintiff. That may have been, she never did really clarify what she was referring to as that windfall.
I guess I'm not being clear here. I don't care if they're duplicative here. You said the tortfeasor is not asserting any rights of the assignor, or assignee. The assignee only had rights to those payments that were duplicative. And so I don't know how you can make your assertion without also making the allegation or making the factual assertion that they were duplicative payments. And that's the assignee's assertion to make, not the tortfeasor's.
Judge, all I know is that the statute says there's an assignment which divests the plaintiff.
Oh, it doesn't say divest the plaintiff.
Well, it
You're
says
saying that,
the injured
that the
victim.
law of assignment, contract assignment, reaches that result, but the statute doesn't say divest.
You're right, you're absolutely correct.
In fact, it says it's for a limited purpose.
That's correct.
It's not a full assignment, it's for the purpose of.
And to the extent the statute applies, there was a full and complete divestment of the plaintiff's rights to pursue the PIP medical paid by the PIP insurer at the end of 18 months. And that means that at the time plaintiff filed the lawsuit, plaintiff had no standing to raise that issue. Standing issues are raised all the time by defendants in cases. You don't have the right to assert that, and that's what I was doing. I wasn't saying that my client received an assignment from the plaintiff, not a bit. And that's what I thought you were referring to when you were talking about the tortfeasor asserting rights of the PIP carrier. Wasn't doing that. I'm just saying at the time the suit was filed, the plaintiff had no right to sue for those limited PIP damages.
We have any further questions? All right, thank you, counsel.
Thank you, Judge.
Appreciate the arguments by all counsel this morning on this case. Court will take this matter under advisement. That concludes